Perfect. Thank you so much, Miss Mia Johnson, for starting the recording. The time is now 5:04 p.m. Good evening and welcome to the February 10th, 2006 Policy and Governance Committee meeting. I am Amy Olivo, Vice Chair and District 4 Board Member. It brings me great pleasure to welcome everyone to tonight's meeting. For those unable to observe now, the meeting is being recorded and can be accessed on the PGCPS YouTube channel for later viewing. Ms. Johnson, can you please call the roll?
Dr. Moss, Miss Oliva,
Present.
Miss Brown, Miss Brown,
Here.
Mr. Briggs,
Present.
Mr. Jackson. There are 3 present.
Thank you. With a quorum present, the Policy and Governance Committee meeting will come to order. If there are no objections, the committee shall adopt the February 10th, 2026 meeting agenda. There being no objection, the February 10th, 2026 meeting agenda is adopted. If there are no corrections, the January 13th, 2026 meeting minutes shall be approved as distributed. There being no corrections, the minutes are approved. Let's see, it looks like we have 2 public speakers for this evening. The chair recognizes the registered speakers for their public comment. To our registered speakers, you are allotted 3 minutes to share your remarks. Speaking time may not be transferred to another individual. The board will not engage in dialogue during this portion of the meeting. Speakers are expected to refrain from using profanity or derogatory language. A warning will be issued once. Continued misconduct may result in the speaker being muted or removed from the meeting. To support a professional and courteous environment, speakers are encouraged to refer to individuals by their title, such as chair, board member, superintendent, or principal, rather than by name. We have 2 public speakers this evening. Our public speakers are Shannon Wilk, individual, on student protections, and then Ryan Sanchez, individual, on keeping students safe from ICE. Mia, is Shannon here?
Yes.
Oh, perfect. Great. Hi, Shannon. We're ready for your comments.
Thank you so very much. Good evening, Dr. Moss, Miss Olivo, and members of the committee. My name is Shannon Wilk, and I'm CASA's Director of Education. CASA provides leadership development, college and career readiness, ESOL courses, and vocational training to both youth and adult immigrants in Prince George's County. I am here this evening to express my sincere gratitude to the committee and to the entire Prince George's County Board of Education for your support of Black and Brown students and your commitment to protecting immigrant families during this time of aggressive and racially motivated immigration enforcement. The draft policy to be reviewed this evening demonstrates PGCPS's commitment to implement the letter and the spirit of the Maryland Values Act. By taking under strong consideration the recommendations presented by the very students and families currently being unjustly targeted by the federal administration, this board has shown a sincere desire to meet this unprecedented moment with policy that affirms the county's commitment to equitable policies developed through authentic community engagement. As this draft policy moves from review to ratification, I request that it then be implemented with the utmost efficiency possible. With ICE's acquisition of additional office space in Prince George's County and plans to undermine existing state law through the expansion of private detention centers, we know that a significant surge in immigration enforcement looms over the horizon. Therefore, it is critical that the district's updated policy on student protections be implemented with speed and fidelity to ensure that all PGCPS employees are well prepared to support and protect our students. Again, I thank you for your leadership. This new policy demonstrates a clear commitment to live up to our Maryland values and serves as an example to all other school districts seeking to ensure their own protections are responsive to the needs of their most impacted students. CASA deeply values our partnership with PGCPS and looks forward to our continued collaboration with the school district to develop policies and best practices that are culturally affirming and rooted in racial equity. Thank you.
Thank you so much, Ms. Welk. Mr. Ryan Sanchez.
So Ryan Sanchez is here. Ryan Sanchez, you will see a message box come up and you have to press accept.
Let's see, Mia, are you possibly able to offer that again, invite him again so that maybe it pops up again in case it disappeared? So Mr. Sanchez, you'll be invited to join as a panelist. And if you can just accept when that option comes up on your screen, that would be great.
So I just sent it again.
Okay. Perfect. Mr. Sanchez, if you're there, hopefully that accept button is up on your screen now that you can click accept, and that will move you over to a panelist so that you can speak at the meeting.
Ryan Sanchez
Okay.
declined.
Okay. Mr. Sanchez, please do feel free to email your comments to us, and we absolutely look forward to receiving them. Thank you so much. We will now move on to the legislative update. The chair recognizes Mrs. Robin Welsh for the legislative update.
Good evening. What I thought I'd do is just go through some bills that are going to be coming up, especially for next week, that I thought might be of interest to the committee, that we can sort of discuss. And then also, Dr. Moss requested that we talk about the autism bill, which is Bill 901. So let me start with I'll just take you through, but excuse me, I apologize. This dog has to go out of this room or she will be jumping. Give me 1 second. You can either go out or stay, but you got to be quiet. You want to go out? You want to go out? Okay, then go lay down. Okay. So the first bill I wanted to bring to your attention is House Bill 154, which is Open Meetings County Boards of Ed Enhanced Requirements, and it is about transparency. So the Local Board of Education Transparency Act. It has to do with making sure that all meetings are videoed and available for the public to see, as well as they're virtual, and the public can participate through virtual. But it goes into a wide range of things like when you have town halls, when you have, just different functions going on at schools, things like that, that maybe you don't have the capacity to be able to video just because of the situation, in terms of meeting with people. And then it also requires that we have to archive the videos for 5 years. So right now we do video a lot. Because all and we do allow for virtual, Both the all the committee meetings, the advisory committee meetings, all of those are virtual. The board meetings are also videoed and live streamed, all the different types of meetings we have. But I know there's sometimes situations where we don't have the capacity, and depending on where or what the event is, that's not an official meeting, but it is definitely an opportunity where say a board member brings a group of community members together to meet with them, and that we don't have necessarily that capacity, especially depending on where that meeting might take place. And right now, IT is looking at what the cost would be for us with our vendor to be able to archive for 5 years, because we do not archive all those videos for 5 years. So I will say that basically there's been a lot of conversation about it. Right now, MABE does oppose this bill. And ironically, what's strange about this bill, what's really strange is right now there are regulations that came through that basically say that you can't have virtual meetings, that they must all be in person, or these specifically your main meetings. So this will be interesting to see how this plays out. I don't have a cost yet, but it will be an unfunded mandate. But I didn't know if there's any conversation or in terms of how people feel about this. So I don't know. Anyone in the
Yeah.
committee has any thoughts on it?
Yeah, colleagues, do you have any questions or thoughts on this? So I will note, oh, I'm sorry, Mr. Briggs.
Okay. Thank you so much. Mrs. Welsh, I just had one question, and that was about the unfunded mandate portion of this.
Uh-huh.
Can you just speak more to that specific part?
Just the fact that it will cost us money, and have talked to the vendor to find out how much it would cost to be able to archive. I mean, we're talking about a lot of meetings and for 5 years. So that I don't know what that cost would be, but that piece is the unfunded mandate part of it.
Okay. So this could be in the millions or in the high hundreds of thousands, essentially.
It could be. I don't know. As soon as I have that, and that's one that's not coming up for hearing until I think it's next week. But it's just important to think about, because for you all, because I don't think and it's also the other thing is that really is important. It takes away the local control, because the board should make a determination on how they have to meet the Open Meetings Act requirement, but the board still has the responsibility to make the decision on how they want to, run these meetings and everything. We have a policy that's going through right now that talks about that. I mean, this is a good example of local control, where the board member, if they can't make it because of whatever they have, dire circumstances, and they can't make it to a board meeting, they can attend virtually. And that was a local decision that you all came together when you put that policy together. So this bill, it takes that away. So,
Thank you.
and then the next one is let me see, Senate Bill 48. And that one, again, is a concern. It is, hold on one second. So Senate Bill 48, actually, it's called Education Public School Construction. And it is clarifying the type of proposals and plans that require approval of state superintendent, and requiring to request and receive approval from the state superintendent before a county board may proceed with certain actions, authorizing interagency commission of school construction to adopt requirements for eligibility for certain state funding, and repealing the requirement for the commission to approve 75% of the preliminary school construction allocations. And we actually do have a fiscal note on that. And give me 1 second. I'm going to move this over here and pull it up. Here we go. And so basically, what our operations office said, that the proposed legislation would require Prince George's County Public Schools to seek state approval for not only alterations and remodels of the school facilities, but also for modular construction and temporary relocations of more than $1 million and change orders over 500,000. This change could negatively impact PGCPS in the delivery of much needed capacity at overutilized schools. Additionally, the initial approvals could increase the cost of construction as there will be additional reviews needed that are not required now. Further, this could lengthen the period of construction as well. And they just said an estimate in terms of contractual services and doing some of this would be an increase of up until 2030, it would be 500,000 each year. And then by 2031, it would be $1 million. So it's one of those bills that not only does it, and we have put in a position to oppose it, but it's one of those bills that not only does it have an unfunded mandate, but again, now we're going through one more step we have to go through with review and approval, and it involves the state superintendent. You know, it already goes through IAC, which they do extensive review of these things. So, so that is one that's coming up in the next weeks, and then the next one, excuse me, is House Bill 473. And that one, we also feel that we need to oppose it. Give me 1 second till I get to it. And that's the Education Collective Bargaining Certificated Employees class size. So this, in the law right now, it says that when they're negotiating contracts, one of the things that they absolutely cannot negotiate is class size. That is definitely management's responsibility to determine, and it's not negotiated. So that would repeal that section of the law. So now there could be negotiations for class size, and we have put it in the our chart or whatever that is that we should oppose it. And the reason being, again, is because if you think about, first of all, sometimes the negotiated agreements don't get finalized till close to the end of the school year. And we've had situations into the next year. And secondly, it would have significant impact in terms of possibly the number of teachers we would need, as far as if they negotiated a very low class size, as well as it could impact the number of classrooms we need. So it has potential for some very serious fiscal impact. And it really is the responsibility of management to determine, you know, the school system, what is the ideal class size that we want to strive for these buildings and stuff. And sometimes there's circumstances you don't have a choice where you might have to have a larger class size. So, so that would be one. And please jump in at any point if anyone has any questions or any discussion or things that they, you know, have a thought on. There is a cell phone policy that's coming up. Bill that, and it's House Bill 525. There's actually several of them right now. And sort of like last year, they are dictating that we have a cell phone policy. So right there, that in itself is concerning because we don't want legislators to tell us what policies we need to have. We do have a policy already, but I'm just saying. And then the one policy requires that everything is stored away. And so if you look at the total cost of what that would be for the school system to get these storable, like these places to store them, that high school wouldn't be so bad because they could stick them in their lockers. But as far as like elementary and middle school, we clearly would need to have you know, some kind of, and that would cost a significant amount of money to make sure all our elementary schools and our middle schools would have places to save, to put the cell phones when they walked in the building. So any questions about that one? And then let me see what else we have. 103. Okay, House Bill 546. And that one is a bill that requires the State Department of Education to make available a continuing professional development course on education or well-being and flourishing to school personnel and administration on or before July 1, 2027. And then our staff would have to take those courses or the course as it relates to their continued professional development in terms of flourishing as a human being. So that's excellent, Mina. So in terms, we certainly always look out for the well-being of our staff. However, number one, there would be money attached to that because we can't be doing professional development during the day. So that means we would have to do it probably after school, which means we'd be paying our staff for those after school costs. So even though MSD is developing the course, it would be an expense for the school system to be able to provide that type of training. Plus, we would have to train the trainers. The trainers of the training would have to get trained before to be able to provide the training. And then House Bill 755 is another cell phone bill, again, which we would want to oppose. And then we have, and these are all coming up the next week. And then the next one, 114, is, so 1 second. Okay, it's educational agreements, procurement contracts, and memorandum of understanding, and reporting and publications. And this is something that we also oppose. We do put a lot on the website as it relates to our procurement and the different types of contracts we have, but it's still to the degree that what this bill is requiring. And if I can get a minute, I can pull this up and just show you, share with you what our fiscal notes said about it. So we actually got a lot of information from procurement and from finance because number one, it would the implementation time to be able to put this in place would be very unrealistic because they're saying July 1, 2026. So now you have to put all these things in place. And then we have to have all of the contracts categorized and published, every agreement that were entered in from July 1, 2025 to July 30th, 2026. And that in itself would take probably a year for us just to completely change our entire process to be able to have all those things on the website. And then it also talks about county oversight of certain aspects of procurement. So that would also change our reporting during this whole transition process, which definitely would make it very difficult. And then also in terms of for every single contract, so not even the ones that we're talking about that hit the threshold and go through board approval, but we have all contracts, very small amounts of money, but loads of contracts. The system would have to report the total amount required to pay versus the actual total amount paid during the fiscal year. So, and I could go into much more detail, but the bottom line here is it is a major administrative burden to be able to meet every single requirement that sits in that bill. I know the whole idea is transparency, and we're not against that by any means, but at the same time, are already, if you think about procurement and finance, they're already overwhelmed with much of what they have to do. And then to add, and also there's audits all the time from the state and, just the regular business, there's audits. And now we're moving through this process where we'd have to put all this into the, on the website and meet all these reporting requirements and everything. We'd probably be hiring extra staff to be able to try to meet this requirement. So this is another unfunded mandate. And then another bill, which I think is a really important bill, is 311, which is the blueprint, House Bill 311. And that one, I think, is hold on 1 second. We feel that one we should support with amendments because there's certain pieces of that bill that are very positive things for the school system. And then there's other pieces that are not that that good. And let me just pull that up. so if you look at the bill, there's different sections. For example, they want to shift the hold harmless for CEP schools through FY27. And then it should remain at they want to then after FY27, they will no longer, it will not be, we won't be held harmless. And therefore, starting FY28, we would then lose probably $90 million because that's about what we get. So we love the fact that they're going to do hold harmless for 27, but we think they need to extend it to 28 because we could not afford to lose $90 million at this point. And then second, there's a let's see what else. Other than that, they do this. There's a change in the law that talks about that would allow school districts up to 2023. That's not correct, but to expand dual enrollment, and there are no blueprint required credits for the dual enrollment. So they're giving us some flexibility in terms of how we are going to implement dual enrollment, and we actually are big advocates of dual enrollment. We don't require any of our students to have to pay for that, and we really try to make every opportunity. So the fact that they would give us that kind of flexibility is very good. And then they would also, there's some language that allows for the use of to be included in just academic instructional types of things, uses there. So again, they're providing a little bit more flexibility, which is something that that we need to have. And then they do have another section but there's no financial implications. So parts of this is very good for us. And then parts of it are definitely we need to we really need to express our thoughts on it. Probably the biggest piece is the fact that our CEP schools would lose that funding starting in 2028, and that's a lot of money, $90 million. So I know we're not at the point. I know the planning group meets on Friday, but I think that's one. I would think that the committee would want to provide some input. I know other systems definitely will be providing input on that one. So I don't know if there's any questions related to that you might have. You're muted, I think. I can't hear you. Oh,
Sorry
sorry.
about that. Board Member Brown or Briggs, do you have any questions or comments? Okay, I'll also just share that I will be testifying on HB 352 on behalf of the Board of Education tomorrow, actually. That bill would take away the sunset provision for the concentration of poverty grants. So that has already been heard in the Senate, and so we've shared a letter of support there, and I'll be testifying in favor of that legislation tomorrow as well. I'll also share that board member chair Dr. Moss and I have been to Annapolis several times. Last week we were able to meet with Senators Charles, Harris, Washington, and Rosapep, and had very productive conversations with them, sharing our legislative priorities. So we are continuing to be very active and work hard in Annapolis on behalf of our school system. I'll just open it up again for any comments or questions before we move on to our proposed policies for the evening. Okay, terrific. So we're moving on to 7.0 on the agenda. There are 3 items for discussion. There will be, oh, I'm sorry. Robin, go ahead.
I'm sorry. I forgot to talk about the autism bill, which
Oh,
that
yes,
Dr. Moss
please, go ahead.
asked. So I'm sorry.
Please
I just
go ahead.
realized that. I'm like, oh no, I have all this information and I didn't share it. And this one just came through, so it won't be a hearing probably for another 2 weeks. So this one is recognition of external diagnosis of autism. And basically what it's saying is that if a parent wants to go out and get their child, they think their child has autism and they want their child to be evaluated by someone outside the school system, that they would go ahead and they could get the evaluation from like a developmental pediatrician or clinical psychologist, licensed psychologist. They have a whole group of people. And then what would happen is the school would be required to initiate a school-based evaluation of the student within 30 days after receiving the external diagnosis of autism and written consent from the student parents. And then during the evaluation period, a school shall provide a student with external autism diagnosis, the supports recommended in the diagnosis. A school may provide alternative supports to a student with a specific recommendation, and also if it conflicts with federal or state law and whether it is a safety at risk. And then the school shall continue to provide supports to students until the school-based evaluation is completed. The determination is made regarding whether a student should continue to receive these supports. So this is a little concerning, first of all, because of the fact that, number one, the schools have sit teams where they are constantly watching how students are doing and put together programs. And even if a student there's a thought that maybe this is a student who needs special education services, it's the responsibility, and this is all in law, it is the responsibility to almost treat that student until they get them through the whole evaluation process and write an IEP and everything. It is the responsibility of the school system to put in place interventions and everything they can to support the student until they complete that. The other thing is that if the law itself basically says that in terms of them, this mostly is focused on services prior to getting the IEP services. But I can tell you that once the evaluation is provided, the outside evaluation frequently, and the law says the school system doesn't have to accept an outside evaluation. They can do their own evaluation, and actually, if we do accept it, frequently the parents will ask for that evaluation to be paid for. The law doesn't say that here, but I know from my own experience and in talking to Dr. Trinell Bowman, that's exactly what would happen. So, and outside evaluations are extremely expensive, but also in federal law and state law talk about the fact that it is the responsibility of the IEP team to make these kinds of determination, or if it's not to the point where they feel that there's need for special ed services, absolutely a 504 team can put together a 504 plan that would address what the needs of the student. So this is very problematic in terms of what would result from this. I think that it has a great potential for increase in costs for the school system, and probably down the road we'd have more probably due process hearings, just because there's a lot of outside evaluators. There's some very good, but some that are in the business of outside evaluations, and the other thing is many of them don't have school-based experience. And in every evaluation that we do of a student, we include the observation of a student in the classroom, because the responsibility of the school system is to help that child be successful in the school setting and do what we can do, so you have to have that school-based observation to know exactly what's happening and using the data from the school. So it would be the recommendation of, and also Trinell had our special ed attorney as well as their two of the special ed attorneys actually, and they have a compliance person review this, and all of those people were saying that this is something we definitely should impose, because I think it could put a major burden on the school system to do that. So I just wanted to review it because he did ask me to review it. But it is not, I haven't seen a date for this one yet, so it will be coming up.
Thank you so much, Mrs. Welsh. Definitely appreciate getting that in the discussion. Any comments or questions about that last bill? Okay.
I'm
Thank
sorry,
you.
because I'm driving, I can't
Oh, yep.
navigate the.
Go ahead. Hmm.
Just real quick, did they talk about a fiscal note? I know you kind of mentioned it because that's the first thing that popped in my head. How much would it cost? Was there an estimated cost? Was that actually brought up when discussion was talked about the bill?
So I did, when I spoke with Ms. Bowman, she said that it would be difficult probably to come up with the cost. I mean, I can go back to her and say, can you please try to give us some insight into what that might cost so that we could, that would help the board have a better understanding. Just so that we would, have a sense of that. I do think, let me go back and just ask her again. So this bill just came in, and then Dr. Moss sent the request, and then I was like the autism bill, and then I finally found the number, and she ended up, I said, if there's any way you can put anything together for this evening, that would be really helpful. So she really quickly, so let me double check with her and make sure, because I did not give her very much time, and there was a lot, for her to be considering. But and then I can certainly share that information with you.
Yeah, no worries. And the reason why I asked too is because I know we are, just as a board, we've agreed that we need to make investments when it comes to special education. And so if this is a part of it, it would just help. So thank you so much.
Okay, I will. I do know that when we put in the legislative platform as one of our major priorities for special education, one of the things that the request was for funding for increased number of special education for programs for students with autism. So I know that is an area that has, is a priority area for the school system. But I'll see what I can find from her.
Thank you.
Terrific. Thank you so much, everyone. So now we will move on to agenda item 7.0, proposed policies. There are 3 items for discussion. There will be 2 rounds per item during the discussion. With each round will be 2.5 minutes. If a third round is required, a vote will be taken. So the first policy for discussion tonight is policy 1700, Disabilities Issues Advisory Board. The chair recognizes Mrs. Welsh to provide an update on this policy.
So I think where we left it was that yourself and Board Member Brown would be having conversations with Diab and then come back to the committee to share that information.
Yes, correct. Thank you. Board Member Brown, would you like to,
Yeah, sure. So we did contact Diab. We had a great successful meeting that did have offer discussions. We also had members of Diab offer just additional suggestions on how we should move forward. And so we're still kind of in the works in the moment of trying to figure out how we can integrate new changes and kind of take it from there. But it was definitely a productive meeting, and we're still kind of working out what other possibilities we can do to expand or keep the scope of work the way that it is. Thank you.
Yes. Thank you so much, Board Member Brown. I think that is a good encapsulation. So based on the fact that we do want to, I think, continue to hold this policy for discussion, this is a question, I think, for Ms. Johnson or Ms. Adline. Do we need to take a vote on this, or do we just leave it here on the agenda? Oh, Mia, you are muted.
I'm asking Cindy through the wall.
Oh, sorry. Okay.
Yeah.
Okay, I'm sorry. I was speaking to one of the staff, so I didn't hear the question earlier. If you could just let me know.
Yeah, I'm sorry. So this is for policy 1700, the Disabilities
Mhm.
Issues Advisory Board. Um, Board Member Brown and I are continuing to have discussions with the Disabilities Issues Advisory Board members on this
Mhm.
policy, and so we would like to hold it here in the discussion phase. So the question is, do we need to take a vote, or would we just move on to the next policy at this point?
Got it. Okay. So you, because it already here to go to the next stage, you will take the vote, but it has to fail.
Ah,
So
okay.
yeah, and then you will make the second, you make the amendment to keep it at the committee level.
Okay,
Mhm.
got it. Does that make sense to everyone then? Perfect. So the question is, shall the committee recommend policy 1700 Disability Issues Advisory Board to this policy's sponsor for revision approval? Any discussion? Ms. Johnson, will you please take the roll?
Ms. Olivo,
No?
Ms. Brown,
No.
Mr. Briggs.
No.
So there are 0 in the affirmative.
Thank you. This motion this motion fails. Is there a motion to retain policy 1700 in the proposed policy presentation / discussion category? Let's see. I think I can make that motion. I move to retain policy 1700 Disability Issues Advisory Board in the policy recommendation / discussion category until the next meeting. Ms. Johnson, will you please take the roll?
Ms. Olivo,
Yes.
Ms. Brown,
Yes.
Mr. Briggs.
Aye.
There are 3 in the affirmative.
Perfect. Thank you, everyone. We'll move on to policy 5115, student appeals of disciplinary action. The chair recognizes Mrs. Welsh to provide an update on policy 5115, student appeals of disciplinary action.
Mia, would you mind posting that so we can go through it? Do you think it could be maybe just a tad, well, the print could be yeah, thanks. That would be good. Okay, thank you. So this is a policy that we have had, it was called originally Student Appeals of Disciplinary Action. And so there's another policy that you have that talks about appeals, the 4205 and 6202 appeals, which will be coming up in the next week, in the next session. And I'm thinking I might actually break those two out to separate policies so that we actually have, and I looked at other counties and they actually have, like, we'll have a policy for 7305, which is student discipline, which is what this one's addressing. And then they have a policy for 6202, which is personnel decisions. And then 4205, which are any disagreements or disputes of a decision that the superintendent has made, and all of these come to the Board of Education. So this one is specific to 7305. And so it's, first of all, it was put into made it into more of the format that we have right now. But it talks about the fact that the board believes that to maintain a safe learning environment of order and discipline, that order and discipline are necessary for effective learning, and the board encourages fostering, teaching, and acknowledging a positive behavior and discretion for schools to impose discipline. And then the purpose of this is really just to lay out the rules of procedure for the Board of Education. for when it is a 7305 appeal. So there is an administrative procedure that actually talks about what has to happen at the school level before it actually gets to and then with the appeal office, who also then it gets appealed there, and it goes through a couple different steps, and that's in that administrative procedure. But this is very specific to what the steps are in terms of rules and procedures for the Board of Education when there's a 7305 appeal. So if you go through this, you'll see, first of all, extensive amount of definitions in terms of the standards. Basically, it talks about the appellant, who is would be the parent who is appealing, or if it was an 18-year-old student appealing the disciplinary action. And then the standard of review is whether the decision was arbitrary or unreasonable. And they determine that by if it's contrary to sound educational policy, or a reasoning mind could not have reasonably reached the conclusion the superintendent or designee reached. And if you've read any state board opinions, they always have a section in that talks about what the standard is, and they talk about these particular standards. And then there's definitions for day, and day is really important because there's timelines for everything in terms of once the decision is made by the appeals office, then how much time the parent has to appeal to the local board, as well as once the decision has been made by the local board, how much time does the parent have to appeal to the state board. So this just lays out in detail what the days and how they're determined. And then the evidentiary hearing is where you get to present evidence and testimony, and both the school system as well as the parent can bring in witnesses, and they can present testimony. And then as far as the two areas that they're looking at either what's going to be appealed is either an expulsion or an extended suspension. Any disciplinary action up to 10, including 10 days, is something that a principal absolutely has the right to do, and therefore it's not appealable. But the ones up until that point. So just so we're clear about the definition for expulsion. For expulsion, it's that the superintendent or designee has determined and outlined the facts that support the finding that the student's return to school prior to the completion of the expulsion period would pose an imminent threat of serious harm to other students or staff, and that the expulsion period is limited to the shortest period practicable. And then also that PGSPS provides the removed student with comparable educational services and appropriate behavioral support services to promote a successful return to the student's regular academic program. So even when a student is expelled, they absolutely are still supposed to be receiving an educational program. And then extended suspension then starts from any time from 11 days through 44 days, school days, which a student would be suspended. And again, it's when the superintendent or designee has determined and outlined the facts that support the finding that the student's return to school prior to completion of the suspension period would pose an imminent threat of serious harm to other students and staff, and that the student has engaged in chronic and extreme disruption to the educational process that has created a substantial barrier to learning for other students across the school day, and other available and appropriate behavioral and disciplinary interventions have been exhausted. So that's a pretty high standard when you think about it, to be able to expel or have an extended suspension, because you're really looking at whether or not the student is, there's an imminent threat of harm, which of course safety is a major priority for all of the schools. And then the fact that the student, if they cannot, they're going to be so disruptive to the school environment that it's really interfering with the education of other students, then that would be the other criteria. And also there's the responsibility of the school system to always look to the providing the shortest number of days for suspension. And up into, and if you read through any of the policies or procedures that talk about school SI teams, the SIT teams, or the SST teams, there's big conversation about all the interventions that need to put in place when a student starts to exhibit behavioral kinds of problems. Because oftentimes the reason you might be seeing very bad behavior. Could be just related to, it could be things that are going on in the home we're not aware of, things the student's trying to deal with, can't seem to resolve, things like that. So that's why interventions are very important to support the student. And then if you continue through other definitions, there's just some like filed or filing, a decision that may be illegal. It also lays out this as in terms of decision making for the board is a decision may be illegal if it has one or more of the following. It's unconstitutional, exceeds the statutory authority or jurisdiction of the superintendent or designee, misconstrues the law, results from unlawful procedure, is an abuse of discretion powers, or is affected by other errors of law. And I do know that when the state board reviews decisions of the local board, they are absolutely looking at these types of things to see, to see both at the school level when it was going through that process and the appeals process with the superintendent, and then when it goes to the school board, that the board review that did we follow all the rules. And then their oral argument is that the parent and the school system that can have an opportunity to actually do a spoken presentation in front of the board. So, and the state board actually allows that too. So that is a possibility. It defines the parent and guardian, which is actually a definition that we've used in many of our other policies, and then it talks about parties and parties, and then presiding officer. And so that could be anyone. It really means the board's chairperson or in a chairperson's absence, or the vice chairperson or in the absence of both, a member designated by the chairperson, or in the absence of such designation, a member designated by the board. And so they can be the presiding officer. And then we talk about the quorum, and that is having a majority of voting board members when they're making a final decision. And then, of course, when you're referring to the state board, it's the Maryland State Board of Education. So when you get down to, if you scroll down further, Mia, then you get to what the standards are. And first, I have a section of applicability. So where does this apply? And this policy governs proceedings that arise from the Maryland Code Section 7305 D5, and then COMAR on appeals from a determination by the superintendent designee related to extended suspensions and expulsion. And then the board reserves the right to request that the parents submit additional documentation of information. And the board also reserves the right to hear oral argument after the hearing has been held. Withdrawal of appeal, the appellant, who would be the parent in this instance, may withdraw their appeal at any point during the procedures if both parties consent. And if there's no mutual consent between the parties, provided then the appellant does not have another proceeding currently pending before the board, they may withdraw their appeal at any time prior to 5 days before the commencement of the scheduled hearing or argument. And then any time before the board issues a final order, they may also request that the presiding officer permit the withdrawal of the appeal, if that's what they want. As far as a designation of a hearing officer, the school board can designate a hearing officer who actually conducts the actual hearing, the evidentiary hearing part of it, and gathers, all the facts, and then basically I have a list of all the requirements that are in the law for who can be a hearing officer. So they have to meet many of these different requirements to be a hearing officer. And most school systems might have a list of hearing officers that they've vetted to make sure they've met all the requirements. And then they rotate using different hearing officers for different appeals. And then the hearing officer basically will review everything, and will present then a record of proceedings and exhibits to the board, and then make available to the parties upon written and the parties and the hearing examiner's findings of fact, conclusion of law, and recommendations to the board and the parties. but then it's still ultimately the board's decision after they have reviewed all the recommendations from the hearing officer, and, have had an opportunity to discuss it, whatever, then ultimately it's still the board's decision to make a decision about, does the suspended suspension or the expulsion, does it stand, or are you going to do away with it and take it off the student's record, and the student won't be expelled or suspended? So in essence, the hearing officer is really going through everything and providing all the information so that the board then can make an informed decision about what, how to proceed. This then goes into a lot of information related to initiation of appeals, in terms of timelines, and then what has to happen. And I'm not going to go through every single one, but it talks about that immediately the superintendent designee shall immediately orally advise the parties of their right to file an appeal to the board within 10 days of the final decision of the letter being issued. So that's a letter that's issued by the Office of Appeals and Hearings, who is the designee for our superintendent. So then the parent does have that opportunity then to do that. And then, let's see, being issued requests for an appeal are acceptable as our appeals filed in person or by U.S. mail. And if appeal is filed by U.S. mail, the filing deadline shall be extended by 3 days. That's good, because sometimes the U.S. mail is not always on time and stuff. So that's very good. And if a notice of appeal is not filed within the time period set forth, then the board shall dismiss the appeal for untimeliness. And the same thing happens at the state board level if the appeal doesn't get filed with the state board within their particular time. And then if you scroll down further, it says that upon receipt of the timely notice of appeal, that it will be signed at a case number. So this is probably, I'm thinking the board office assigns it a case number, and then the board office will consult with the appellants or the appellant's representatives and the superintendent's designee to schedule the hearing. And once a hearing date is selected, the board shall refer the matter to a hearing. And I should say, so I put this all together, but this is your opportunity, because if you're saying, well, wait a minute, we don't do it that way, or we do this or that, unless it's something that's against the law, you absolutely can do it the way you want to do it. So I'm just letting you know that I've reviewed a lot of things, and it's also in line with a lot of what we have in the 60202 and 4205 policy. And then the hearing is going to be conducted as soon as possible. After receipt of a time request of a hearing, then a request for a postponement may be filed with the board office if there's a need, but all postponements must be submitted no later than 5 business days prior to the actual scheduled hearing, unless there is a showing of good cause. And then, let's see, the board office must send the request to other parties within 2 business days, and then the other party will have 2 business days to respond. So it's pretty tight timeline in there to back and forth, so that that should be followed. Let's see, and then when an appeal is filed, the principal and the principal supervisors, which would be the instructional director, and the Office of Appeals and Hearing, would be notified. Because usually when there's a hearing, generally speaking, the hearing examiner is going to want to hear from the principal, possibly if there's a teacher involved, whoever, and then to be able to really make a good decision. And then the notes of information below actually applies to both hearings and oral arguments before the board. And there are times when if there's a particular circumstances, sometimes hearings and oral arguments may be held virtually. I do know the Office of Appeals and Hearings, they run most of their hearings virtually. I'm not sure, and you all know more about it because you do it all the time. So I'm not sure what you do it at the school board level, but it's certainly an option. And then generally speaking, especially for students, most of these hearings they must be private unless the parent would request that it be a public hearing, and then it could be a public hearing. And then there the pre-hearing issues, both the appellant and the superintendent are really encouraged to stipulate to the admissibility of documents right from the beginning, because that does help cut the amount of time that's happening in hearings. And then the superintendent shall provide the appellant, which is the parent, with the school system's witness list and a copy of the documents that the school system will present at the hearing, no less than 5 days before the hearing. And the appellant is encouraged to provide the superintendent with the appellant's witness list and copy of the documents that the appellant will present at the hearing no less than 5 days before the hearing. So I know this is pretty extensive, but many of these parents, when they are deciding to appeal, many times I'm thinking they probably do bring also attorneys to argue their cases. And if they do have an attorney, unfortunately, if they don't, that's a different story. But if they do have an attorney, the attorney is very familiar with these timelines. And then all parties may bring counsel to the hearing, and the parents and the students shall advise the board if they are represented by an attorney or other representative promptly after retaining counsel. Let's see. Our accurate records of the lower meetings, disputes, and controversies shall be kept by the superintendent, so that if an appeal to the board is taken, the records shall be submitted. And then, and that would be the Office of Appeals. They would be maintaining those records. And then the presiding officer shall prepare a cause to be prepared an official record, which shall include the pleadings, testimony, exhibits, and other memorandum or materials filed in the proceedings. And then the last thing is an electronic record of that part of the proceedings, which involves presentation of evidence, shall be made at the expense of the board. The record need not be transcribed, however, unless it's requested by the presiding officer, a party to the controversy, the superintendent, the board, the state superintendent of schools, or the state board. So it doesn't have to be transcribed, but if you're getting requests from any of these people, then guess what? It needs to be transcribed. So, and then in the event that it is transcribed, it is the board's executive responsibility to arrange for its production, for its delivery of appropriate parties. The cost of any type of transcription of the proceedings or part of any proceeding shall be paid by the appellant or the board, depending on who requested to the transcript. So if the school board requested, then of course they're going to pay for it. If the parents requested, they'll pay for it. And then duties and authorities of the presiding officer. So the presiding officer shall have charge of the hearing with authority to permit the examination of witnesses, admit evidence, rules of admissibility, rules of request for continuance, adjourn, or receive, sort of like the judge in a regular court case where they are making these kinds of decisions. And the presiding officer calls an oath to be administered to all witnesses testifying in the proceeding. Now, it says here the superintendent may administer the oath to witnesses, but of course that's not a requirement. That's something that may happen, but you don't have to do it. And then each oral argument before the board shall be held before not less than a quorum of the board. So if you are going to allow oral arguments by the superintendent or the parent, then you must have a quorum of the board present to do that. And then it goes into order of proceedings and just the whole step of let's see what's going to happen when the parties present their case. So at the outset of the hearing, the parties may make a brief opening statement. Again, they're making their opening statement like you would see in a court case, which an appeal is taken, and then the issues that they wish the board to decide. And then the superintendent designee and the student or parent or their representative shall advise the presiding officer if there are any stipulations of fact, the stipulations as to admission of any documents. And such stipulations are strongly encouraged when appropriate. And then the superintendent designee shall proceed first in the presentation of evidence, and then followed by the appellant. And it is the appellant that carries the burden of persuasion in these hearings. After each party has been given the opportunity to make opening statements and to present documentary and testimonial evidence, then the presiding officer shall then afford each party the opportunity to present closing statements. Again, just like a court case. Now, the section in terms of examination of witnesses and introduction of evidence so when you think about strict judicial rules of evidence, if you were in a civil or criminal case, they're very strict. But and when it comes to a hearing like this, they're not. Those strict rules of evidence shall not be applicable to hearings conducted under this policy. In each case, the test of admissibility shall be whether the evidence is reasonably relevant to material issue and whether it has substantial probative value with respect to such a material issue. For example, sometimes you see people that will provide lots of evidence, and it's different types of evidence, but it's actually for the same reason, to prove such and such. Well, that's repetitive, and sometimes your hearing officer will object and say, no, you already provide this information. You're wasting our time providing more of the same. And then let's see what else. Hearings conducted under this policy, individually or by through counsel or rep, may submit evidence, examine a party individually or by or through counsel may present evidence, examine and cross-examine witnesses, and make objections and file motions. Again, it reminds you like a court case. And then the presiding officer. So even though you have your attorneys that will support you, that will represent you in these cases, the presiding officer can also stop and ask questions of the witness. And this is very extensive. So normally our policies don't go into this kind of detail, but this is your policy. And generally you do not do administrative procedures for, this would be something you'd probably see in an administrative procedure. Because of the nature of it though, that's why it is in such detail, so that you know exactly what are the steps. And this hopefully provides guidance on how you would you complete these things. And then you can also the parties can present written memoranda of the issues and facts of laws, and then with the approval of the presiding officer and on such schedule as the presiding officer may designate, written memorandum may be submitted after a hearing. And a lot of times in cases like this, the hearing officer will say, even for closing arguments, instead of providing closing arguments, we will end the hearing now, but you will be given 30 days basically to then provide this information to the hearing officer, and then he will read everything and review it. In hearings, so it says, in hearings and oral arguments conducted by the board may retain an attorney who is not employed by the board's counsel of legal office if that office is representing I'm sorry, that's a mistake here. That should be a superintendent in proceedings to participate in any hearing or oral arguments as counsel for the board. And I had that highlighted because I didn't know exactly, does our board's counsel, are they the ones that represent the board in these cases, or do you actually hire a special counsel to be able to represent the board in these cases? I don't know, or to represent the superintendent, I guess. Let's see, the attorney who is not employed by the board's counsel legal is that office representing the CEO in proceedings. I guess it would be general counsel, really, more than anything, that would represent the superintendent. Then your standard of review is arbitrary, unreasonable, or illegal. So any decision that has to be made has to be reasonable. It can't be arbitrary, and it has to be legal. And again, the appellant has the burden of persuasion. Let's see. And this numbering is off. Okay, the board. So in terms of deliberation, decisions, and orders, the board, in reviewing the hearing examiner's recommendations, this is after a decision, but may call as a witness any person whose testimony may be relevant and material. Any witness that is so called shall be called in a session that is open to both the parties and their counsel. So you get the decision from the hearing officer, and you're reading this, and you say, we need a little bit more information. So you can have it says an open session. Is that correct? Did I read that correctly? No, open to both parties. You can have a specific session at which then you as the board would bring in these people, and you would, question them and everything. And of course, you would be sending out notice to the parties. And then after deliberating on an appeal in executive session, the board shall vote at the next open public business meeting immediately following the executive session. And identifying information of the student and parent guardian will not be revealed at the public business meeting. So generally, I think if I recall, you might have a section at the very end of your open meeting where you'll say we're going to vote on session items from the executive session. it's pretty general, but that's when you do your voting. Because it does have to be an open session. And then, the board shall, so finally, after the public business meeting, the board shall issue a final written order within 5 days indicating the board's decision and reasons. And if the board does not accept the hearing examiner's recommendation, the board's written decision shall set forth the board's findings of fact, conclusions of law, and the specific disposition of the case and the board's rationale. And that's really important, that piece, because you want that to be as substantial as possible, only because if the party does decide to appeal to the state board, that's going to be important information that the state board is going to look at. And then the board's written decision shall advise the parties their right to appeal the board's decision to the state board if taken in writing within 30 days of the date of the written decision. So the parents do have, or the school system for that matter, they have 30 days to appeal. It wouldn't be it would really be the parents. They would have had 30 days to appeal. So now they have a little bit more time to get prepared and make a decision if they want to appeal the decision. And then the board's written decision shall be issued within 45 days from the date of the appeal was received. So there's a timeline then for the board in terms of actually after they get all the information from the hearing examiner, developing their written decision and issuing it within 45 days from the appeal. Let's see. And then in the event that there can be a request for an extension of time if due to extra circumstances or unusual complexity, the board determines that it will be unable to hear an appeal and issue a decision within 45 days. The board may petition the state superintendent. So if you can't meet the deadline to be able to do it, then that's something you would then, and I know this has happened before, where they would then contact the state superintendent and get permission to be able to extend the timeline. And then as far as ex parte communication, just like it is when you think about, if you watch anything on TV with hearings and stuff, you cannot be talking to the judge. And that would be the same situation here. And then extensions or shortening of time for good cause, the board upon its own motion or at the request of either party may at any time shorten or extend the time provided under this policy for filing any documents, providing any notice except in those instances where the time is specified by state law. And then, let's see what else. I think I took all that out. I think that's it, believe it or not. And then we get to implementation responsibilities. So now this does say the superintendent is authorized to develop an administrative procedure to address this policy. And now that I'm looking at this, I have to say that after I spend so much time with this, I did get a little blurry-eyed. So I need to look at that because I don't know that we want an administrative procedure at this point. I will check with OGC only because of the fact that this is in quite a lot of detail already in terms of how you're going to operate. So I'm not sure I'm not sure what you'd put in the administrative procedure when you have all this information. I will double check on that to be certain. And then the other thing is the board office should provide an annual report to the board setting forth in the most recent completed school year the number of the appeals filed, by bargaining. That's incorrect. Oh, I know that was not highlighted. I know why I was asking the question. So that is language we have in the other one. And I wanted to know whether or not as a board, as the committee, that you would want to have that report by the board office in terms of the number of appeals filed as it relates to 7305. And if you do, then I will revise this to incorporate that information. And that's something you can tell me, and then I can get that taken care of. And that's it.
Okay, thank you, Mrs. Welch. What a detailed policy. I'd like to open this up for questions from my colleagues. Mr. Briggs.
Thank you so much. Mrs. Welch, I had one, I guess, question for an addition here, and this was for Standard 3, Section B, which is designation of hearing examiners. One of the things that I really think would be good to kind of maybe spell out is how we actually select the hearing examiner. So it states that we select it, but whether that's referencing another policy or it's outlining the actual process for that, I think that would be something that I would love to see in this policy. And then the other piece is you mentioned in also that same section, I believe it was number 3 or so, that a hearing, or number 4, a hearing examiner's kind of responsibilities for providing evidence-based rationale. In the event that that doesn't happen, because we know that people are flawed and they make mistakes, it would be nice to have like a clear process for the board to understand how we would remove a hearing examiner if they continuously are presenting information that isn't, well vetted and thought out, so that we can ensure the integrity of the appeals process. So those are 2 things that I would add in to that.
Okay, that's good. Can you, you were, the first thing you said, section 3 or 4 in the beginning under the standards. I don't want to miss it.
Yeah, it was section, so it's standards, and it's B, which I believe is designation of hearing.
B, okay. And you were saying you wanted to know, so it does say that the board shall interview and select individuals, and then it says the 3 criteria. So you're asking for more specific information on how you would select that hearing officer?
Well, I guess my thinking is, and thanks for asking the question, I was actually thinking since I've been on the board, we've never actually selected a hearing examiner. So I don't know that we necessarily know what that process is. And I think if we lay it out in this policy, then at least we'll have step-by-step process, or at least a high level, beginning point for how
Okay.
to address it. Yeah.
Okay, we can do that.
Thank you.
Thank you, Mr. Briggs. Ms. Brown?
Yes, thank you so much, Vice Chair Olivo, excuse me. This is to Vice Chair Briggs' point. Is there even a reference point as far as how the board is supposed to, like, because you said, oh, the board is supposed to hire the hearing examiner. Is that going to be referenced in the policy if there's a policy that's already done? Because obviously we don't want to reinvent the wheel, but if this is known information, I put this in quotes, is that going to be referenced in this policy as well?
For how you go about the process of actually hiring the hearing officer?
Yes.
I can certainly add information about that.
Yeah, because you noted that the board is supposed to hire, so I didn't know if that was something that was already established, and if it is established, if we can add that, to the references or appendix or how we do things.
Okay.
Thank you.
Great. Thank you, Board Member Brown. Are there any additional questions or comments? Okay. Seeing none, let's see. The question is, shall the committee recommend policy 5115, student appeals of disciplinary action, to the policy sponsor for revision approval? Any discussion? Ms. Johnson, will you please take the roll?
Ms. Olivo,
Aye.
Ms. Brown,
Aye.
Mr. Briggs.
Aye.
There are 3 in the affirmative.
Thank you so much. Let's move on to policy 3186, cost estimates for board resolutions, and this is a rescission. The chair recognizes Mrs. Welsh to provide an update on policy 3186, cost estimates for board resolutions.
So actually, I'm ahead of myself, and I think what happened was the other policy that we had, which was for a revision had to do with proclamations. And what we had thought about was putting proclamations and resolutions together in the same policy. Because we do have one in the 9,000s that talk about proclamations. Unfortunately, I think what happened when we added all these additional policies, that one got taken out. And this one remained as a rescission. And I missed it completely because I wasn't thinking about the two. I was merely trying to get an update of what we were going to do, the policies, because of, Dr. Moss had requested a couple additional ones. And so I think what we need to do is we need to go back and actually grab the policy that has to do with the resolutions. And if you don't mind, we can work on that one and then and incorporate this one into that one. And then once that's happened, then we can rescind this one. So I think that would probably be the smartest thing to do.
Okay, that does make sense. So based on what happened earlier, my guess is that we do need to take a vote on this, but that we would vote no on this in order to be able to bring it up again in the future. Is there any questions or discussions about that? Okay. The question is, shall the committee recommend policy 3186, cost estimates for board resolutions, to the policy sponsor for revision approval? Any discussion? I've asked that like 3 times, sorry. Ms. Johnson, please take the roll call vote.
Miss Olivo,
No.
Miss Brown,
No.
Mr. Briggs.
No.
There are 0 in the affirmative.
Okay, thank you. So we will be able to bring this policy back up later as Mrs. Welsh recommended. I would like to ask if it's possible to rearrange the agenda, and this might need a motion, to move 8.0 policies for second consideration to be the last item on the agenda, in order to give Dr. Moss the opportunity to join us for that particular agenda item. Is there a move from I'll put forward the motion to move item 8.0 below item 9.0, below the items under 9.0. Is there any discussion? Okay, Ms. Johnson, can you please take the roll on that motion to swap 8.0 and 9.0?
Miss Olivo,
Aye.
Miss Brown,
Aye.
Mr. Briggs.
Aye.
There are 3 in the affirmative.
Thank you so much. So let's open up 9.0, policies for third consideration, to advance to the full board for enactment. We have policy 5122, requirements for participation in interscholastic activities, and policy 0105, parent, family, and community involvement. The policies under agenda items 9.1 and 9.2 were submitted for public comment. There are no public comments on 5122. One public comment was received for policy 0105, parent, family, and community involvement. The chair recognizes Mrs. Welsh to share the comments received on policy 0105.
Mia, can you post those? Can you put them up so we can talk about them? And I think if you scroll, okay, that's good. So the first one, 0105, which has to do with family and parent and community involvement. As a parent of this lady has said, as a parent of Prince George's County, oh, wait a minute. As a parent of Prince George's County Public Schools, they do appreciate our continued commitment to strengthening that policy. The language of the policy clearly recognizes the student's success. However, I urge the Policy and Governance Committee to strengthen this policy by ensuring accountability, consistency, and transparency in its implementation. While the policy outlines strong expectations, many families continue to experience inconsistent communication, limited opportunities for meaningful input, and uneven engagement practices for schools, school to school, without clear enforceable measures and defined outcomes. The policy risks being aspirational rather than actionable. So this particular parent is requesting that we put some language into that policy so that it would address accountability in terms of the things that we have talked about. I know there's many sections in that policy that are requirements of the school system. And then that's cut off, I think. I urge the Policy and Governance Committee, because I looked at that earlier and I couldn't see the rest of it. Okay. And then,
Oh,
okay,
here we
good.
go.
I
Yeah.
see it. Okay. And I also asked the committee to clarify how parent feedback is used in decision making at both the school and district levels. Families need to know that their voices lead to measurable changes, not just opportunities to speak. Additionally, equity must be reflected in practice by ensuring multilingual families, working parents, caregivers, and families of students with disabilities are actively supported and not intentionally excluded. Finally, I encourage the committee to make the required annual report of this policy publicly accessible and parent-friendly with opportunities for families to review and discuss. Can you scroll up for just a tad, Mia, so we can, oh yes, thank you. To review and discuss the findings. Transparency builds trust, and trust in essential, authentic engagement. So the only thing I would caution is that there's many ways to do the things that are in the current policy, and schools, although I mean it is a system of schools. However, schools they have different communities, and they're run sometimes, and I want to say differently, but there's just different ways of how they operate. Not say that they should not be in compliance with what's in this policy, but I don't know that you would want to be too restrictive, only because some schools are, quite imaginative in terms of the things that they might do. And others maybe do it in a little bit different way. So I don't know. It's just a thought.
Thanks, Robin. I do think this is an important comment, and I also agree that because this is a system-wide policy, we do run the risk of being too prescriptive with it. I wanted to open this up to board member comments or feedback as well, especially regarding if you'd like to make any updates to the policy based on this public comment. Oh, I'm sorry, I just lost. Okay. Great. Go ahead, Mrs. Welsh.
The only thing that I would think about is the piece where he said that about the accountability, that, and I would agree with that I'd have to really think hard about how that could even be done, but I don't think we do have any language at all in the policy that really talks about accountability. but yet I know we have language in the policy that talks about like what teachers are supposed to do and what principals are, that type of thing. So, and I'm just trying to think about like what we need to do, but maybe it's something to at least look at in terms of the accountability piece to ensure that schools are doing. They can do it in their own way, but they need to do it. They need to be doing it. There needs to be some level of accountability. That would be a recommendation I would have.
Okay, thank you. Mr. Briggs?
Yeah, thank you so much. I think I guess my thinking on this is that it's sort of difficult to enforce accountability across schools. One, I think to the point that Mrs. Welsh was making, that various schools have different approaches to things. But then I think two, to the point that the commenter was making, which is that, we don't want this to be aspirational. It doesn't have teeth, but it might be disingenuous to suggest that having this in a policy means that we are enforcing it in some way across schools in a even-handed way. And so I'm wondering if there's time to think more about how we would do that, how we would implement this. I think maybe if we have some more time to think through, because that might be just a cultural shift at the system level, and what that means. And this could be something that's included in principal evaluations, right? Meeting certain requirements. And that may be a workaround to what they're getting at in the policy. So I'm wondering if in itself, if we're staying true to what the comment was, which is not being aspirational and actually having those accountability pieces, thinking about where is the best place to do this. And it may be this policy, but it might not be. And that's my thinking.
Thank you, Mr. Briggs. Mrs. Brown, Board Member Brown?
Yeah, so when I was looking at the comment, I feel like we're really close as far as the line between administrative procedures and board policies, especially when it comes to accountability. When it comes to the schools, yes, we provide oversight, but I feel like when it comes to that accountability piece, we would have to look to make sure that it doesn't contradict administrative procedures when it talks about accountability for our schools, our teachers, and things like that. I didn't know if there was anything additional that you can kind of talk to about that, Mrs. Welsh.
Well, actually, based on what you said and what Board Member Briggs said, I'm thinking to myself, well, actually, what you could do is in the implementation section, talk about the fact that the superintendent will develop an administrative procedure to implement this policy, which will also include an accountability piece. And then it would be the people responsible for putting that administrative procedure together that they could bring it down to that school level to really have a conversation and make a decision on maybe what would be the best way to go to do it. I'm just thinking that might be the better way to go. I don't know, just a thought.
I am wondering if it might be possible for us to pause this discussion and move back to 8.0 now that Dr. Moss is here, so that we can take a vote on that one and then move back forward to this to finish this discussion. Would that be okay with folks? Okay, terrific. So we are now moving to item 8.0 on the agenda, policies for second consideration, public comment. The question is, shall the committee release the policy under agenda item 8.1 for public comment? Is there any discussion? Yes, Mrs. Welsh?
I did want to point out that did add a few things to the policy based on recommendation of OGC, as well as trying to make also include clarity. So we want to just look at that very quickly. We could, if Mia could put it up. It's not many changes, but it's really more about clarity than anything. So if you scroll down, Mia, to the second page. And I highlighted so we could know for sure. So these are, we talk about the principal and buildings, but we have a lot of business buildings that have business, business like Sasser and where we have all our operational stuff and everything. And we talk about principal / designee, but it doesn't really talk about who's responsible for those buildings. And they do have designated building administrators. So I wanted to provide a definition for that. And I do see And I used what we've used in other policies for designated building administrator. I need to change the CO to a superintendent, but that was one. And then to provide
Mrs.
more.
Welsh, if I could, I'm so sorry. I'm so sorry to interrupt. We only have Felton for about 30 more seconds, and so
Oh,
I
well,
would
then,
like
well,
to
we can go
move
back and do it. So it's nothing
to
significant.
the vote so that we can, and this will go out for public comment. And so we do have a lot of time still, based on public comments, which I anticipate will be robust, to take another look at this. The question is, shall the committee release the policy under agenda item 8.1 for public discussion? Any discussion? Okay, thank you. Ms. Johnson, can you please take the roll call?
Dr. Moss,
Aye.
Ms. Olivo,
Aye.
Ms. Brown,
Given my professional role with the federal government, I'm going to respectfully abstain from participating in the discussion and abstain. Thank you.
Thank you.
Mr. Briggs.
Aye.
There are 3 in the affirmative.
Thank you so much, Mia Johnson. Miss, thank you so much, Miss Johnson. There are 3 in the affirmative. The policy under agenda item 8.1 will be released for public comment. Thank you so much, Dr. Moss, for being here. I know you're in the middle of speaking at a conference, so really appreciate it. Okay, thank you, everyone. With that, we can go back to our policies 9.0. We were specifically discussing the parent, family, and community involvement policy. And I think based on what Mrs. Welsh was discussing, the question is, or a question for consideration would be if the board would like to add the requirement that the superintendent create an administrative policy here that would outline accountability measures for this policy. So I would open that idea up to discussion from the board. Board Member Brown, please.
Yes, thank you so much. So my question is, did they give specifics? Because it seemed a little vague as far as accountability. And so I'm not exactly sure what the ask is or what the primary ask is. It just seemed really broad. So if there was something that they wanted to zero in on, I would feel more comfortable understanding and voting for it. I don't know, maybe we can ask for additional information before moving it forward. But to me, the statement seemed just a bit vague, and I wasn't really fully understanding what to ask as far as what accountability looks like. Thank you.
Mm-hmm.
So what they say is she urges the committee to strengthen this policy by, and you're right, then it says ensuring accountability, consistency, and transparency in its implementation. Then it says, while the policy outlines strong communication expectations, many families continue to experience, so she's talking about, I guess, her own personal experiences, inconsistent communication, limited opportunities for meaningful input, and uneven engagement practices from school to school. Without clear enforcement measures, the defined outcomes, this policy rises, risk being aspirational rather than actionable. So nothing specific, it's really more general in terms of accountability.
Mr. Briggs, Board Member Briggs.
Thank you so much. I think Mrs. Welsh, I'm just going to go off of having talked to many community members about this. And I think the sentiment is that when they go to schools, I think especially post-pandemic, what I've heard a number of times is that families want to be back in schools. They want to be welcome. They want to be meaningful partners in any decisions that are happening at the school level. We know the board is not the only place where decisions are made, and we do more governance. And we know that the district level is not the only place where decisions are made. And that hyper-local piece, I think, is very important. We know that PTAs have a great deal of, support, but not every school has a PTA, and those are things. So I think the goal here is like mitigating that, right? You go across schools, some schools have PTAs and PTOs, some don't. Some schools have principals who are more engaging and staff that can help with that, and some don't. So I think if we can have some way to standardize, and maybe that is what you're saying and what you're getting at, where you said we have something for the superintendent to enforce accountability with an administrative procedure, then I would be on board with that. I just think that I hear the point, and I've heard this a number of times, which is that families want to know that it's not just saying we're welcoming you in for the sake of welcoming you in, but you are a part of the decision-making process at your school and how we could think through that. So if that sparks anything for you more around like where this could fit or how we could do that, then I think that maybe that's worth the discussion. But otherwise, I agree with what you were saying. I think that a superintendent administrative procedure could be a good start for that.
I don't have my hand up.
Board Member Brown.
Yeah, Vice Chair Briggs brought up a really good point. Of course, schools have their own autonomy on how they want things to be done. My concern too about pressuring the administration into this accountability is that some schools, and I'll give, you gave the example of PTAs. If we said every school needs to make sure they have a PTA, some schools just do not have the capacity. Some schools do not have the feasibility, and it's unrealistic for us to put an expectation across the board. And so that's why streamlining it even more would be a lot more helpful. So what do they mean? Are they saying, okay, across all schools, parents should be able to go inside of the schools? Is that something that they want to implement? That needs to be said, because I know, yes, there are some schools that some parents can go and become volunteers. There are some schools that parents cannot become volunteers. That has not, and this is for transparency, what Vice Chair Briggs was saying, there has not been standard language as far as why some schools are not accepting volunteers and why some schools are accepting volunteers. But to put it as a baseline, as this is what everybody has to do moving forward, I think that might cause some discrepancies, and I think that some schools may not, they just don't have the capacity to be able to do things to that matter. We have to also consider that as well.
Thank you, Board Member Brown. Go ahead. Go ahead, Ms. Walsh.
So I was just thinking as you were talking, so, I think it's 146 schools now are community schools in Prince George's County. And then you think about, and so probably of all the schools there, probably more involved with their communities. I'm just wondering if there's, and they do these assessments of, for the school and the community, and that's a determination of how then they're going to spend their money and do what they're doing. But I'm assuming that assessment, it should not be done in isolation, that it would involve assessing also the community, getting input from the community to determine that assessment. I'm wondering, and I could certainly look into this to see, like, what did and that's by law that they're required to do certain things, but it might be helpful. There might be something to learn from seeing what the community schools do, because the parent engagement is a major part of the community schools. I don't know, just a thought ran through my head as you were talking.
Thank you. Board Member Briggs?
Yeah, can I just propose, I think maybe it sounds like we're all in agreement that we have more time with this policy to really think about what's the right next step. And maybe Mrs. Welsh, the next step is developing, curating all of the different possibilities of what could be, and we can kind of discuss or have that shared beforehand so we can read through it and then discuss at the next policy meeting. Because I agree, I think we should make something that is, universal to some extent if we can.
I think that's a great suggestion, Board Member Briggs. And so as I call for this vote, I'm going to separate out the two policies so we can take two votes instead of one. So the question is, Shall the committee recommend policy 5122, requirements for participation in interscholastic athletics, to the full board for enactment? Ms. Johnson, will you please take the roll?
Miss Olivo,
Aye.
Miss Brown,
Aye.
Mr. Briggs.
Aye.
Oh, there are 3 in the affirmative.
Perfect. So then I believe what we need to do is take the vote on policy 0105. If that vote fails, then we can take a second vote to postpone that policy to the next Policy and Governance Committee meeting. So the question is, shall the committee recommend policy 0105, parent, family, and community involvement, to the full board for enactment? Ms. Johnson, can you please call the roll call vote?
Miss Olivo,
No?
Miss Brown,
No.
Mr. Briggs.
No.
There are 0 in the affirmative.
Thank you, Ms. Johnson. The question is, shall the committee postpone policy 0105, parent, family, and community involvement, to the next Policy and Governance Committee meeting? Is there any discussion? Ms. Johnson, please take the roll call vote.
Miss Olivo,
Aye.
Miss Brown,
Aye.
Mr. Briggs.
Aye.
There are 4 in the affirmative.
I think 3 in the affirmative.
Oh, I'm sorry. Yes, thank you.
Yep,
3.
that's okay.
Thank you.
We have our ghost vote here. Okay, great. So policy number 0105 will be postponed until the next Policy and Governance Committee meeting for further consideration. We're moving on to item 10.0, adjournment. The chair informs the public that the next virtual Policy and Governance Committee meeting will be held on February 24th, 2026. Please continue to check the Prince George's County Board of Education website for meeting information and updates. Thank you all for watching. Thank you everyone for this extended meeting and discussion. To our viewers, thank you for watching. To our commenters, thank you for providing comments. There being no further business, the time is now 6:51. The February 10th, 2026 Policy and Governance Committee meeting is adjourned. Thank you so much, everyone.